Hello, and thank you so much for attending our regulatory mastery training series on informed consent, waivers, and alterations. I'm Nicole Vouvalis. I'm the Executive Director of Human Research Protections here at Utah State University, and we're going to spend about the next hour or so talking in depth about informed consent. Thank you so much for taking the time to join us. I know, especially as we approach the end of the semester, things get very busy. First, an overview of the Institutional Review Board and a little bit about the context in which it sits. The Institutional Review Board is an independent committee that is charged with the ethical review, revision, and approval of research involving human participants. The IRB's members of the IRB further the university's research mission by prospectively reviewing proposed research that involves human participants. And we are working to ensure that the protection of those participants are present, that justice, beneficence, and respect for persons is also present in all of USU's research involving human participants, that we are all working together to create a culture of ethical concern and prioritization of research participant interests. And of course, we're doing some work on compliance, especially with international, indigenous, sovereign, federal, state, local, and university requirements for the conduct of human research participants. The Institutional Review Board sits within the Human Research Protection Program. So the Human Research Protection Program is the umbrella within which the IRB is housed. It also houses some of these other components. So we have USU offices and personnel who share in the goal of promoting infrastructures for research at Utah State University that prioritize the protection of human research participants in all work. And so a lot of that work comes out of my office. So we're sort of the hub and in the wheel of human research protections. And within that broader wheel, the spokes all come out to our conflict of interest office, our university ethics and compliance office, the various privacy offices that we work with, IT, institutional conflicts, sponsored programs. We coordinate with all of those offices to ensure that once research is approved, it can actually hit the ground running. We also work directly with participants, for example. We receive complaints and concerns from research participants when they reach out. Most often we are just resolving questions from research participants who just see our phone number and are like, hey, can you resend me that survey URL for that study I agreed to participate in? And we don't always have that information, but we can usually locate what study they are participating in and at least get them connected with you all as the researchers. Other things that we do are things like this: provide this training, make sure that city training is available to you, have a website that is full of information researchers might need in order to successfully navigate the IRB review process. And so that's all stuff that is necessary for a really strong human research protection program, but doesn't fall directly within the purview of the IRB itself. So moving on to the next component, the Institutional Review Board is the entity at Utah State University that has the sole responsibility for approving, requiring revision in, or disapproving research involving human participants. And when I say sole, I will say that that does apply specifically to approval. So other units on campus could require modifications in a research project. Other units could say no to a research project even after the IRB has said yes. But no human subjects research conducted by Utah State University affiliates can move forward until the IRB has granted approval for that research. And the IRB is working to do that in line with established ethical standards, of course, policies and procedures, and best practices that attach to human research protections. Finally, and I'd argue most importantly, the last aspect of our human research protection program is the researchers themselves. So these are the folks, you all, who conceive of the research, you're implementing these protections in your day-to-day work involving people, and you are the ones ultimately responsible for taking the best care of your research participants, ensuring that their experience in research is a good one, and making sure that you're adhering to the commitments that you have made to them throughout the research process. So really, you all are the most important piece of our human research protection program because you're in the best position to impact the experience that a research participant has while participating in your research program. So that's a little bit about our human research protection program. It is all overseen by the Vice President for Research, who at this time is Lisa Barreau. And so she's the one who signs our federal-wide assurance and makes certain assertions to the federal government, to our accreditors, to other institutions that we are engaging in collaborative review with. So it's overseen by her at a high level, and then of course those pieces delegated to each of us as strong members of the Human Research Protection Program here at Utah State University. Okay, let's talk a little bit about the standards that we use here at Utah State University. In order to accept any federal funding for research with human participants, Utah State University is required to establish review standards for all of its portfolio of human subjects research. So, Utah State University applies the Belmont Report principles to the entirety of its human subjects research portfolio. We'll talk a little bit more about the Belmont Report in just a moment because it's particularly applicable to the topic we are visiting about today. But the Belmont Report provides overarching ethical guidelines for the use of human research participants. Those overarching principles are respect for persons, justice, and beneficence. Every review the IRB conducts at Utah State University is looking to ensure the presence of those principles. Then we also have 45 CFR 46, which is more often referred to as the common rule. And 45 CFR 46 is a bit broader. It contains requirements, for example, about the composition of an IRB. So what must an IRB look like? What are the minimum criteria for approval for a human subjects research project? 45 CFR 46 outlines the precise exemption categories that we are allowed to apply to research here at Utah State University. And it has subparts. There are 3 populations that the common rule says are vulnerable, although recent edits have thankfully taken subpart B, pregnant women, out of that vulnerability category, though subpart B is still a standalone category of the common rule. And so we have subpart A, which is the general requirements, B for pregnant persons not listed here, and then subparts C and D. C is for research with incarcerated persons, and D is for research with children. And so each of those subparts have special requirements that attach anytime you are performing research with those particular populations. And we do have on our training website separate trainings just like this one that we've held regarding doing research with justice involved participants, as well as 2 separate ones that are that touch on working with children. One working with children broadly, and a second about working with students in particular, both of which contain some of the requirements regarding children. The Belmont Report and the Common Rule are in many ways substantially the same thing. And so we're going to visit a little bit more about the intersection of those things in just a moment. But so just so you know, functionally, these application standards look very much the same. 45 CFR 46 is very much just a regulatory implementation of the principles of the Belmont Report. And so we'll visit about them separately, but also in tandem throughout the rest of this training. And here I just want to pause and say, I want to make sure that I'm paying attention to the slides and to my notes. So I will try to answer a question from you if I receive one during the course of the training, but I may not see it in real time. And in that case, we do have 15 to 20 minutes reserved at the end for Q&A. And so if I cannot answer your question live, we will get to it at the end of the training. Okay, let's talk a little bit more about the Belmont Report. The Belmont Report is a foundational document in the United States for research involving human participants. And the report comes out of a commission that was created in the National Research Act of 1974. So that act of Congress charged a commission with identifying the basic ethical principles that should underlie the conduct of both biomedical and behavioral research involving human participants in the United States. That commission, called the National Commission for the Protection of Human Subjects of Biomedical and Behavioral Research, met at the Smithsonian Belmont Conference Center, which is how the Belmont Report became called the Belmont Report. And it produced what everyone who has taken city training now knows as the Belmont Report. It was that report, a lot of folks don't know, was actually formally adopted by what is now the agency Health and Human Services. It was published in the Federal Register for notice and comment, and after a period of time, formally adopted as policy by the federal government. And so for almost 20 years, there was no common rule. There was only the Belmont Report. The Belmont Report was produced 2 years after the commission was created in 1974 as a result of the National Research Act of 1974. And its membership included 11 appointed individuals, most of whom were scientists and physicians, a couple lawyers like yours truly, gotta make sure the rules are clearly written, and then one civil rights activist. I haven't been able to find anything directly on this, but probably because the National Research Act was in many ways a direct response to the discoveries that we learned about when the Tuskegee syphilis experiments came to light. Then those were conducted by the Public Health Service. And so the engagement of someone who was actively working in civil rights was probably very appropriate for the time where the Belmont principles were being conceived of and documented as something that should be integral to the involvement of human research participants in the United States moving forward. So that's just a bit of background about the Belmont Report. And here we have a photo of the lovely mansion that is the Belmont Conference Center, where these folks spent just about 2 weeks coming up with the Belmont Report. Within the Belmont standards, we have respect for persons. Respect for persons is the primary driver behind informed consent requirements. And so if we're using Belmont standards as a benchmark, as the slide says, to respect a person is to give appropriate weight to the person's opinions and their choices. Respect for persons is summarized in the Belmont Report really, though, as holding two ethical convictions. First, that individuals should be treated as autonomous agents and their decisions respected. But second, that persons with diminished autonomy are entitled to additional protection. And so there in those two bulleted pieces, you can see sort of a little bit about how that gets implemented. So we demonstrate respect by ensuring that folks have what they need in order to make an informed decision about participation and respecting that decision. But then also, we demonstrate respect sometimes by providing extensive protection, in the words of the Belmont Report. So that might account for informational advantages that researchers and institutions hold because they know more about the topic of the research than many of the folks who would be participating or targeted for participation in research. And also accounting for scenarios where an individual might not be fully capable of self-determination. So children is one of the most common applications of this. Children are considered to be minority by default in terms of just age minority, meaning the law has not given them sufficient ability to engage in self-determination. It is always an adult making a legally binding decision on behalf of a child. And so that is certainly one of the many contexts in which the Belmont Report is speaking to where respect for persons might actually look like stepping in over the autonomy of a person if that person does not have full ability for self-determination. So looking here at the common rule 45 CFR 46 came much later, not until 1991. And so we're sort of operating with the Belmont as our overarching policy standard in the United States from 1976 until 1991. And the common rule was seen very much as a formal implementation of the Belmont principles. At the time that it was passed in 1991, it was codified in separate regulations. So 45 CFR 46 was sort of copied over into very different areas of the Federal Register and administrative code by 15 federal departments and agencies. As of today, 19 federal agencies are signatories to the Common Rule. An important outsider being the Food and Drug Administration. They have their own set of regulations. However, they are in the process of harmonizing their regulatory infrastructure to be in line with the Common Rule. And that was a directive of the 21st Century Cures Act, which was passed in 2016. So we are actually not going to visit about FDA standards for informed consent. I will briefly note here that in many respects, waivers and alterations do differ. Utah State University is not able to review research that falls under the FDA regulations. We don't have a school of pharmacy. We don't have a medical school. Some of the pieces that are really integral to having an IRB that is allowed to review under FDA regs. So I just want to note here, those requirements do differ. We are not talking about FDA regulated research today. Today, we are talking about research that falls under the common rule and research that is just more commonly performed here at Utah State University. So that might also include unfunded research. So coming back to the common rule, at Utah State University, we are responsible for implementing both common rule and Belmont standards into our research portfolios. At a high level, we do this via USU Policy 584. USU Policy 584 is Utah State University's way of communicating its broad-based expectations for the conduct of research with a human participant while you are affiliated with Utah State University. More specifics than the policy level would allow are found in Utah State University's IRB standard operating procedures, which are also available on our website. There's a link to that on our resources slide at the end, but irb.usu.edu/procedures, or if you just go to irb.usu.edu, procedures is again one of the main tabs in our top navigation. So really easy to find your way there and locate the specifics of USU IRB operating standards. Okay. Starting to dig in then to actual informed consent standards and expectations. The common rule outlines two sort of general structures that govern informed consent. The first is the informed consent process, and the second is the informed consent documentation. There are approximately 11 pages of regulatory text to the common rule. 4 of those are explicitly about informed consent processes and informed consent documentation requirements. So as you're engaging with us in a review, you will probably note that a disproportionate number of action items for researchers deal with the informed consent section. That is very much in line with also the common rule expectations for how research should be designed and communicated to research participants. Informed consent, or giving people full information and allowing them to decide whether to move forward with the study, is arguably one of the most important regulatory structures that we can put in place for protecting research participants. And so we do spend probably a disproportionate amount of time in our reviews focused very clearly on that. And that importance is certainly reflected in the common rule itself, as well as the Belmont report in its discussion of the application of the principle of respect for persons. So our biggest concerns during the review process, I would say, do center around fully understanding what it is that's being asked of prospective research participants, and then working to ensure that the most important facets of that understanding are being communicated to research participants. So we want to make sure we have enough information to conceive of a consent process and document that is appropriate, and then we want to make sure that that is being communicated very clearly to research participants, with some exceptions that we'll talk about when we get to alterations and waivers. So let's talk a little bit about informed consent standards at the IRB. So we've talked already about Belmont principles and common rule requirements. Those are two really important ones. They drive certainly the bulk of our standard operating procedures and our template guidance and all of that that surrounds informed consent. But just so folks know, on top of that, we also have accreditation requirements. So USU is an AHRP accredited institution. And what that means is that we are going beyond the regulatory floor and we are implementing what are considered to be best practices in the field of human research protections. And then we also have a whole bunch of other stuff. So state and federal and sovereign and international and context-specific requirements that we are also making sure are present whenever we are reviewing a protocol that is submitted to us for review. Okay, so let's visit about just some of those other things. That last one is context-specific requirements. And so here's just honestly a few of them. We are making sure that all of these infrastructures are being represented in our review processes. So let's take a step back to when I talked a little bit about the Human Research Protection Program earlier. The IRB and its review is the largest portion of why you file a protocol when you're engaging in research with living persons. You know that you have to apply to the IRB before you can conduct research with a living person. But Utah State University also is an entity that must ensure compliance across a great many areas, including some of the ones I've listed here. And its HRPP is no exception to one of these compliance spaces. So one of the reasons the Human Research Protections Office is a standalone entity is to assist USU in achieving its legal and compliance obligations. And we're doing that by making sure that when a human subjects research protocol is approved by the IRB, it is also approved in a manner that allows it to get up and go as soon as that approval has been obtained. So when you submit to the IRB, you're also submitting to the Human Research Protections Office within the context of the Human Research Protection Program. All of these different requirements are going to have to be met. USU has chosen to implement them all in one space rather than sending researchers to 10 different areas to get 10 different opinions and approvals. So while we are the IRB, we are also the institution's privacy board, which means you only have to go, if you're working with protected health information, to one place to obtain a waiver if you need a HIPAA waiver. Because we are also acting as the privacy board, we're sort of doing that all in one fell swoop. We are also approving your HIPAA authorizations. We are approving your documentation under FERPA to make sure that your requests comply with FERPA. We are looking to make sure that if you're doing research in the European Union, you are adhering to the General Data Protection Regulation, which requires specific and signed informed consent when you are asking about certain topics. When you are engaging with children in an online setting, we are working to make sure that you are complying with COPPA, the Children's Online Privacy Protection Act. And if the courts ever decide what they want to do about Utah's social media laws, we will also be making sure that you get parental permission to engage with children on social media if that is part of your research plans. And so we are an ethics and risks and benefits space. We are also sort of a one-stop compliance shop when it comes to all things human subjects research related. And so our informed consent guidance and our templates and our information online is designed really to capture all of that in one fell swoop. So again, researchers don't have to go to 10 different places to get an answer about what applies to their program of research. So that's a long way of saying there's a lot that's sort of worked up in what we're about to talk about today. Because our office is required to ensure that the technical and legal pieces that are required for you to move forward are all in place so that Utah State University can feel confident that its human research protection program is operating in a compliant manner. So, detailed regulatory requirements. Let's go. What is informed consent? It is the communication process during which an individual is given important information about a procedure or treatment, and that interaction results in agreement or disagreement by that individual to undergo the procedure or treatment based on knowledge of relevant facts. Procedure here, we're not just talking about a medical procedure, we are talking about also research procedures. In most cases, for informed consent to be legally effective, it must also be documented. And so here you see what we talked about just a couple of slides ago. Informed consent is both a process and a document. And so the process is arguably as important as the document in terms of facilitating participant understanding. So in our office, I use the word baseline informed consent processes or baseline informed consent procedures. And when we say that, what we mean by it under the common rule is that a prospective participant is given complete, relevant information about the study, that they make a decision whether to enroll after having a meaningful opportunity to consult with other people. That might be a loved one who they've talked to about the condition under study. That might be having an opportunity to ask members of the research team questions. It might be making sure with their employer that they can get time off that they need to participate in research procedures. That consultation piece is a critical part of what we are also evaluating. And finally, the document piece, right? The prospective participant signs and prints their name and the date on a document, an executed copy of which is returned to them for their own records. That is the baseline understanding of what the common rule expects out of an informed consent process, absent a waiver or an alteration. So this has a couple of terms. I call it baseline. Other IRBs refer to it as an unaltered informed consent process. But this is what it looks like at base. It also assumes that a few things are absent. So one of the things that we are required to ensure are not present in an informed consent process is undue influence and coercion. Oh, I see a question at the bottom. Okay, what does executed copy mean? Most of the time, we don't have them sign the copy they take home. Yeah, so technically, returned and executed copy is having them sign 2 copies. In practice, though, we do not apply the common rule to every single study we review. We are given a little bit of flexibility unless that study is federally funded. And so this is one of the things that we really do not enforce with people unless there's a strong need to. So this is one of the spaces where we get some flexibility. But in a perfect world, research teams would indeed have a way for participants to receive an executed copy of their informed consent document. In practice, I would say 10 studies a year set it up like that. And we receive, hundreds of studies a year. So yeah, you're welcome. And thanks. I'm glad I was able to catch that before I moved on to the next slide. So okay, 2 things cannot be present in the informed consent process. So we are, in addition to being charged with making sure that certain things are present, we must also find and document that the informed consent process does not allow for undue influence or coercion. A lot of people use these terms interchangeably. But I will take a moment to note here that 99.999% of the time when we say either one of those terms, we mean undue influence. Undue influence is influence by which a person is induced to act otherwise than by their own free will without adequate attention to the consequences. Coercion is the practice of persuading someone to do something by use of force or threats. If you are using threats to enroll people in your study, we are going to have a very different conversation than the one we're having here today. But I'm happy to say I don't think I've ever seen such a thing in all my time at Utah State University. So here are some examples. Compensation that is so great relative to the study procedures that research participants aren't even considering the procedures. So, a sign that says $50 for 5 minutes of your time. What is that? People are not actually taking the procedures into account. And so you are impacting by having outsized compensation, a participant's ability to meaningfully consider the procedures, which, as we noted on the definitional slide, is a critical component of having informed consent. So where your compensation is so great, you might have consent, but it may not be fully informed. Someone in a position of power asking a prospective participant to agree to the research. For example, the recent USHE climate survey. While I know that it is confidential and anonymous, though I have questions about how it can be both, I still felt like I needed to participate because USHE, my boss's boss's boss, said that they wanted us to do this thing. And so that is what undue influence might look like. It's putting someone in a position where, sure, they can say no, but can they really say no? And so that's another piece of what we must find is not present in order to approve a research protocol. Informing a participant that they cannot access needed medical care unless they participate in research. So that might look something like coercion. That looks a little bit more on the side of a threat. So I know you need this thing and I know that I can provide this thing, but I'm not going to give it to you. I'm going to withhold it unless you do this other thing that should be both optional and voluntary. So those are just some examples of the applications of those. The first 2, again, being more examples of undue influence. The last being a model for what something like coercion might look like. Okay, we're not going to read all of these, but these are all of the required elements of informed consent as laid out in 45 CFR 46, Section 116. That section is titled General Requirements for Informed Consent. The first half of that section deals with the process of obtaining informed consent. So some of that we already visited about in terms of process. The second half is dedicated to required and additional elements of informed consent. So these are the required ones. That means that these elements are required in all cases. And then next we have additional elements. So just to visit about a few of these, a statement that the study involves research. So if you are conducting research, the expectation is that you tell people that you're conducting research. For for participants for whom this might be applicable, a disclosure of appropriate alternative procedures that might be advantageous to the subject. So a lot of folks wonder why we ask such detailed questions about the procedures that participants will undergo. A huge part of that is so that we can work with our reviewers to determine what alternative procedures might be appropriate to disclose to people before they decide whether they'd like to participate in a research study. And so that's a space where it is a requirement of informed consent, but we do have to ask questions sort of outside of our informed consent section of the protocol in order to make sure that we are meeting the required elements of informed consent adequately. An explanation of who to contact for answers to pertinent questions about the research and research subjects' rights, identification of a person to contact in the event of a research-related injury. If your study is federally funded or it is a clinical trial under the federal definition, it is required to have a key information section. And all of these items are in our templates. So we'll talk about our templates toward the end, but we do, rather than have you work through these, make sure that you're communicating these in the ways that our collaborators at the federal government expect them to be. We have built out template language. And just so you know, we are actually working on updating our templates, hopefully as a project this summer. So we're working to simplify those even more than they already are because they are pretty long and complicated. Okay, so the next set are additional elements of informed consent. So these are ones that are supposed to be included whenever they are applicable to the study. So anticipated circumstances under which the subject's participation may be terminated. We're seeing that actually most commonly in our online studies where we are screening or where researchers are screening for bots or fraudulent participants. So making sure that you are giving reasonable information about what it's going to look like if you terminate a participant from the study. The consequences of a subject's decision to withdraw from the research and how they should do that if they wish to withdraw from the research. A statement about whether participants' biospecimens or information are going to be used for commercial profit. And if so, then you have to also include a statement about whether the participant will or will not share in that commercial profit. Whether your research will involve whole genome sequencing. So these are all elements that you don't necessarily need to include if you're not doing them. So if these aren't relevant, then it could just confuse your consent form and probably should be left out. But where these things do apply, it is important that they be communicated. So if you say, I'm never going to terminate a participant ever, then as long as that's actually true, you don't need a section about how or why you might terminate a participant. And so these are, again, pieces where relevant, they should be involved. Into these amendments. I'm going to come to these questions a little bit later, just because I think they are a little more complex than the overview piece, and I think they'd be a good piece for our Q&A section at the end. So, okay. Moving on to additional requirements. So those are the required and additional elements of informed consent. So each of these things that you've seen on the screen are spelled out in 45 CFR 46, section 116. And then we have one other piece that is an IRB responsibility. So the previous items are ones that technically are researcher responsibilities. So they say the researchers are responsible for disclosing this information. And the IRB is just responsible for making sure that it's there. But the IRB is then separately charged with identifying any additional information other than that specified in 116 that should be given to the subjects when, in the IRB's judgment, the information would meaningfully add to the protection of rights and welfare of subjects. And so our template has 4 areas that are not specifically called out in the regulations, but are generally requirements either of our accreditors or other best practices in the field that we do generally ask folks to include. And here are those spaces. So information about confidentiality disclosures, technically not required by the Common Rule, but is something that meaningfully adds to the protection of rights and welfare of our research participants. payment or compensation information, the use of information protected by other legal structures. So for example, if you are using educational records in your research, then FERPA applies to your research. And so we try to also make your consent form adhere to the requirements of FERPA so that you don't have to have 6 forms, you only have to have 1 form. And then COI disclosure. So if there's a conflict of interest that impacts the conduct of the research, one management plan option might be to disclose that conflict. And if participants know about the conflict and they choose to participate anyway, then that is one effective method of managing a conflict. So those are spaces where we do have information in our template that can be taken out if it's not relevant, where we have sort of adopted our Section 109 requirements of what the IRB thinks would be meaningful for research, or for a prospective research participant to engage with before making a decision about whether to enroll in research. Okay, so let's start to talk about waivers or alterations. An informed consent waiver is requested where there will be no process or document informing research participants of their participation in the study. That is sort of a blanket, like doing research and I'm not going to tell anybody that they're in it. So the requirements of an informed consent waiver are that the IRB find and document that the research involved no more than minimal risk to subjects, that the research could not practicably be carried out without the requested waiver. Practicable means without extreme difficulty or expense. That if the research involves identifiable private information or identifiable biospecimens, that the research could not practicably be carried out without using such information or biospecimens in the identifiable format. The waiver will not adversely affect the rights and welfare of the subjects, and whenever appropriate, the subjects or legally authorized representatives will be provided with additional pertinent information after participation. I have a little asterisk there because if you're providing information after the fact, most of the time you need an alteration. But we'll talk about alterations in a moment. So these are the baseline requirements for requesting a waiver of informed consent. And by informed consent, I mean both process and document. So if you are going to not do both of those things, you must qualify for a waiver meeting each of these 5 criteria. And as we mentioned, practicable means cannot be done without extreme difficulty or expense. And minimal risk is, of course, a central piece of what IRBs are tasked with determining the existence of. And so it's that the probability or magnitude of harm or discomfort are not greater in and of themselves than those of other everyday activities or routine clinical procedures. And so you must have a minimal risk project in order to qualify for a waiver. And this can get tricky because sometimes there are projects that are not minimal risk where a waiver would be appropriate for like one segment of the study. So say, for example, you have a 2-part study. The first part is a relatively benign survey, and you're going to invite certain survey participants into, say, phase 2 of your study. It is very difficult to meet the waiver requirement for the first part of your study, even though your survey piece might be pretty benign and not impacted by the greater than minimal risk study if your next study is a clinical procedure, but it's not a routine clinical procedure. That might be a space where waivers are, in fact, more difficult to come by. A lot of folks have advocated, our institution included, for the ability to separate research out into phases and apply different risk determinations to different phases of the work. That way we can apply waivers where appropriate and not where not. Happily, I will say, here at Utah State University, the vast majority of our research is minimal risk. It is, I don't have precise numbers on this, but I would say fewer than less than 3% of our research portfolio carries a greater than minimal risk designation. And so most people are not sort of opted out of the waiver availability just by virtue of the type of work that is being done here at Utah State University. Moving on to alterations. An alteration is requested where there will be an adjustment to the process or document informing research participants of their participation in the study. So it's different from a waiver in that information is going to occur. You're going to tell people that they're participating in research. Maybe not right up front, but at some point they will receive information relevant to their participation. So let's visit. I didn't one by one the requirements because they are essentially the same as the requirements for a waiver. And so in order to approve an alteration, the IRB must find and document that the research involves no more than minimal risk, could not practically be carried out without the requested alteration, the same piece about the identifiable format portion of the work, that the alteration will not adversely affect the rights and welfare of the subjects, and whenever appropriate, that the subjects or legally authorized representatives will be provided with additional pertinent information after participation. That's the most common application of an alteration. So let's look at a couple of examples. A waiver would be appropriate where a researcher who has legitimate educational interests would access student essays submitted to last semester's class for research. So those essays are they're being accessed for a research purpose. They cannot be de-identified because they're essays, and you will be able to match whose essay was whose, unless the students wrote the same exact essay, in which case AI probably did that for them. The students will never be notified that their educational records are being utilized. So this technically comports with FERPA because you have the legitimate educational interest exception to FERPA. And in this case, a waiver would say that you're never going to tell the students at all that they're participating in research. An alteration looks a little bit different. So that might be a researcher with permission from their department head will place students into one of two recitation sections. Those two recitation sections are going to be different. One's a control, one's an experimental group. You as a researcher are asking permission to use student course records. So you're engaging with the students. You are going to ask them for their informed consent to access their course records. But you do not want to disclose that their recitation conditions are different or what they are, or even that there are different conditions until the semester has ended so that you don't bias the way students are engaging with the course. The students will then receive a debrief at the end of the semester that explains everything. And I didn't write it here, but one of the things we would require you to do is also to make sure that there wasn't a meaningful difference in performance between the two sections, to make sure that one section was systematically disadvantaged relative to the other, and to make appropriate adjustments from there. So there, because the students are receiving a debrief, and implicit in that is that they are agreeing to remain in the study after they've been debriefed, you've altered the process, right? So you didn't tell them up front everything that they would need to know about participating in the study, but you did tell them at some point. So you've just altered the order of how your study will proceed. Whereas that waiver is the students will never know. They will not be informed that their information is being used for a research purpose. They will not have an ability to withdraw from the research or say no to the research. Qualifies for a total waiver. So that is one application of the difference between a waiver and an alteration. Here's another. Researchers will reach out to venue owners to inquire about hosting one of two events in that venue space. Some people are going to reach out asking to host Pride Prom, and then others are going to reach out to host a panel of speakers on vote by mail versus in-person election processes. The researchers are reaching out not because they want to host an event in that space, but because they're seeking information on illegal discrimination. They're never going to tell the venue owners the real reason for the contact, but they're looking to see whether the responsiveness differs or if the pricing for using that space differs. So those are the sorts of things they're looking for. They are reaching out, they are interacting with participants, unlike the last one, but they're never going to say what the real purpose of the study was. An alteration of a similar sort of situation might look different. So they'll contact local venue owners and that they're conducting market research. So they want to ask about rates that would be charged for certain numbers of attendees and certain number of equipment needs, assuming that the number of attendees and equipment needs for Pride Prom versus the panel of speakers on election processes is the same. So the real reason for reaching out with that survey is to discern whether the owners will treat the events differently, give it different pricing, give it fewer dates of availability at the venue, things like that. And then at the end of the survey, there's a debrief. And that debrief explains the true nature of the study, and it allows the participants to decide whether, having just engaged in that survey, the study team can continue to use their responses. That's an alteration. So again, in the first case, we're interacting with participants, but we're not telling them that we're doing research. We're not telling them the topic of the research. We're not giving them an opportunity to have their responses counted or not counted in the data that we're going to use to analyze and address our research questions. But in the alteration scenario, the participants will be told after they've engaged with the procedures. So again, it's not informed consent because it's not prospective. It's not the sort of baseline informed consent process, but all of the elements are there. They're just out of order. And so by agreeing to continue to allow my data to be used, I am signing, I'm dating, I'm saying, yes, you can use my information, knowing full well now what it was and what the purpose of its collection is. So again, that's a difference between a waiver and an alteration. Let's take a modification of the scenario and actually talk about one that's a little bit different. So let's say the research team is doing the second thing, the alteration scenario, but at the end, they're not going to ask for permission to keep the data. Participants know the truth, but there's no opt-out from there. It's an alteration because there is, you are taking some of the elements and you're moving them around, but it's also a waiver because you're not getting the full informed consent from the participants. So they have the information, but they have not consented at that point. So in such a case, we actually have both a waiver and an alteration. Happily, since the criteria are the same, if you qualify for the alteration, you qualify for the waiver as well. In most cases, there could be a world where the alteration doesn't impact their rights and welfare, but a full waiver would. But I've never seen that here. I do also just want to note that the ethics of a study like this would typically not allow you to do the thing I've just described. So most journals actually demand that a participant be debriefed and have the opportunity to withdraw their data. And they will not agree to publish an article where that debrief and withdraw process did not take place. And so many IRBs have updated their processes in recent years because if a study cannot be published, it also impacts the IRB's determinations regarding benefits. So in many cases in these deception studies, the benefit of doing the study is to make clear something that is difficult to get at if you're telling people the honest truth about it. And so if you cannot publish that study, then the benefit of it is difficult to realize. And of course, the IRB must find that the benefits of conducting a study outweigh the risks of study participation to participants. And so this is often a space where we say, if you're going to deceive people, you must have a debrief and an ability to withdraw data once they have full information about the study. So that's just some background information, but these examples I think do help illustrate the difference of when one might request a waiver versus when one might request an alteration. Okay, so those are process pieces that we've just talked about, waivers and alterations of process. We're going to now talk about waivers of documentation. So these waivers are specific to how the documents for informed consent get utilized or not. There are 3 different types of waivers of documentation. The first is where the confidentiality of the participant, potential breach of confidentiality to the participant is the primary risk of the study. And this one's a little bit tricky because it applies way more often than this waiver is utilized. And that is for the third requirement that is on this screen. So the IRB can issue a waiver of documentation, which means that you do not have to get a signed and dated document from your research participants saying that they've reviewed the information and agree to participate in your study. where the greatest risk to participants are around being identified as taking part of the research project or the information that they are sharing in the research project. And the informed consent document would be the only written evidence of their participation. So let's say it's an anonymous survey on deviant behavior. The informed consent document is the only piece of paper or record affiliated with that study that indicates that a participant has engaged with that study. In many cases, participation alone could be risky. If you're engaging in a survey about illegal behavior where only people who engage in that illegal behavior are being targeted, the very nature of participating presents risks to participants. And so in this case, you can request a waiver of documentation, which means the participant has received all of the information about the study that is normally required. They simply are not signing for their agreement. So you can request that type of waiver as long as the only record linking the subject and the research would be the informed consent form. The principal risk in the research would be potential harm resulting from breach of confidentiality. And here's the tricky part, each subject will be asked whether the subject wants documentation linking the subject with their research, and their wishes will govern. So in order to utilize this waiver documentation, you must ask the subject whether they want to have a signed form or whether they'd prefer not to. And if they say they want it, you have to honor that wish. And that's the tricky part because this applies most often in online studies. And we see that researchers really just don't want to design two separate consent processes. And so while a lot of studies meet these criteria for a waiver of documentation, we actually don't see it utilized very often just because the implementation piece can be quite difficult to get together. This is far and away our most commonly applied waiver of documentation. And that is, I sort of summarize that as where written consent would not normally be required outside of the research context. So this one only has two requirements, that the research presents no more than minimal risk of harm to subjects, and the research involves no procedures for which written consent is normally required outside of the research context. And so one of the things that we ask researchers to provide when they're requesting this type of waiver is to give us an example of a similar procedure outside of the research context where no signature is required. That way, we can easily document the finding that we are required to, as you can see from the slide, both find and document. And so there is a field directly in your quality protocol that allows you to say, this research is most similar to this non-research procedure, and in neither case would people normally be asked to sign for their consent. Please do not request this waiver if it is a context in which you would normally sign a form. So like anything at your doctor's office requires usually informed consent to treat, or informed consent specific to a procedure. And so if it is a clinical procedure, for example, this would not be the most applicable waiver. Finally, the last waiver of documentation that is available is one I sort of refer to as cultural expectations or cultural norms. This waiver of documentation is appropriate where signing forms is not the norm for the cultural context where you are conducting your work. And so to qualify for a waiver of documentation of informed consent, the IRB must both find and document that subjects are members of a distinct cultural group or community in which signing forms is not the norm, and the research presents no more than minimal risk of harm to subjects, and there is an appropriate alternative mechanism for documenting that informed consent was obtained. And so for this, we ask that you come prepared in your application to share resources with the IRB that surrounds that cultural context and the culturally appropriate ways in which one would document informed consent. So those are the three waivers of documentation. Again, waivers of documentation still assume that all of the information that is required in 116, 117, 109 are still being presented to participants. It's just that you are not having them sign the form to agree to the research. So you're still giving participants documentation of what they are agreeing to participate in. If that is not the case, you probably need a process-based waiver or alteration rather than a waiver of documentation, which has its own specific criteria as outlined on these previous slides. Our documentation for this is our letter of information template. So the letter of information is essentially the same thing as the informed consent document. It just does not have the signature block, and there are a few modifications throughout the document that don't assume like making a selection for something like retaining contact information, pieces like that. All of that sort of prospective documentation stuff has also been pulled from that template so that it makes good sense for your context of not having a signature and not taking a record from the research participant of their agreement to participate. So it still assumes that they are absolutely receiving and engaging with information that is pertinent to participating in that study. It really is just about not getting a signature, printed name, and a date. If that's not the only thing you want to change, again, you want a waiver or alteration more generally, not a waiver of documentation. So with that, that's sort of my wrap up of the overview of alterations and waivers. Here we have some resources that might be applicable. So because so much of this stems from the Belmont report, we have a link directly to the Belmont report as well as a video about the Belmont report. But I would say one of the most important things that we make available here are our informed consent templates. I noted that there were sort of 4 spaces where we have an area on our template for something that isn't a direct regulatory requirement. So as you're working through our templates, every single other part of that page is something that is a regulatory requirement that we have tried to translate into more plain English language for our research participants. I also want to note here, our templates are made for the most common type of participant that we see, and that is a college-enrolled or college-educated adult, with the exception of our ASCENT templates, which are, of course, geared toward children. If that's not the population you are working with, please do modify the language that is utilized in that form. The concepts are all there. The elements that are required are there, but you absolutely should feel free to modify the language to make sure that it appeals and speaks to and is clear to the participant population that you are directly working with. One other thing I will say about our templates. First of all, you never have to use them, but if you don't, you do still have to make sure everything is in there that needs to be in there. And so you could use this presentation or these slides as a resource to do that. But if you are going to use our template, some of the best advice that I can give you is not to use a version of that form from a protocol that has been previously approved. One of the biggest reasons for that is, as we noted, there are those sort of additional criteria that are required. And in a study where you're taking an informed consent document that's already been approved, one of the pieces might have been pulled out of that template because it didn't apply to that study, but now it does apply to this study. And so you're going to get feedback that tells you to go back to the template and find that language and make sure you get it added back in and that you're disclosing things to participants that weren't present or weren't necessary out of your last study. That causes so much more hassle and work for you, I think, than working through the template and filling in those gaps as directed throughout the template. So my best advice to you is to work through a new template with each new study. You can certainly pull information from previously approved templates. So if you're, describing a procedure and that procedure has been used in other informed consent templates, that's fantastic. Please do feel free to do that. But make sure you're going section by section to ensure that you're not leaving out something that is regulatorily required. The Office for Human Research Protections within HHS makes a participant-centered informed consent training available. It's a pretty good training. I recommend it. They do say it takes about 95 minutes to work through. I found it did not take quite that long for me. And then finally, 2 other big resources that we encourage folks to use is to request a consultation. We have a submission form on our website. Really, it's on any page of our website. So if you just went to irb.usu.edu, there's a consultation request button in the top right corner of every page of our website. And our Ask the IRB Slack. We are active on Slack all day. And we love answering questions there. You can use this as sort of it's like an 8 to 5 sort of help chat, which as a millennial who hates picking up the phone, I prefer. I will pop that into our webinar chat right now, since that link is something I can just provide in the moment. So with that, I think as promised, we're leaving about 20 minutes left for Q&A.
So I can bring up a couple of the Q&A issues that were in the pop-up menu.
Perfect.
Indu Garg asked early on, are there any subparts on research? And I think this was a question about subparts of the Belmont report
Okay.
about intellectually disabled individuals.
No, there are mentions of educationally or socioeconomically disadvantaged populations, or folks with diminished capacity in the rest of the common rule. So those mentions are in subpart A, but there is no specific subpart B, C, D, or beyond that deals with folks with intellectual disabilities.
And I don't know if that individual has a follow-up question or not. If they do, encourage them to put that into the Q&A. And while we're waiting, the next question was, what is the difference between children that have a participant status versus a Confederate status in a research study?
Oh, that's a great question. I can probably answer it. I don't know that children is the linchpin there. I think the critical piece there is whether somebody is a research participant or not, because informed consent is a baseline expectation for any research participant. So a research participant, technically defined as a human subject in the regulations. I really don't like the word subject, it just rubs me wrong, so I try to say participant. But the definition of a human subject is a living person about whom an investigator obtains identifiable private information or identifiable biospecimens, or interacts or intervenes with a person to generate data for a research study. And so a Confederate, a true Confederate, is someone that you're not obtaining data about or from. You're just telling them what to do. They're basically like a paid actor reading a script for you, right? That person's not a human subject because you're not collecting data about them. You as a researcher aren't intervening or interacting with them for a research purpose, like you're staging the research with them. And so a Confederate, where you're not collecting any data about them, might be someone you tell, like, hey, walk across the quad wearing this obnoxiously colored shirt. I'm going to count the number of people who turn their heads to look at you after you've walked by. The subjects there are the people who are reacting to your intervention, not the person carrying out your intervention. So if it is a subject, baseline expectations around informed consent adhere. If it's a true Confederate, you're not collecting any data about them, you're not asking them to do anything different for a research purpose that you're separately going to analyze any information about. Again, think of them as like a paid actor for your study. That person has no informed consent requirement expectations, although moving into my compliance role, I will say that legal affairs will tell you that if you're going to record something that uses a Confederate, you do need a release to use their likeness in your materials. And so while you don't need informed consent, we probably would ask you, hey, if you're recording this intervention that people are going to interact with, have you had that person sign a release form? But it's not informed consent, and it's not really something we delve into. It's just something we make you aware of.
So let me just ask a little follow-up about that.
Yeah.
If the Confederate is acting on their own, they're not following a prearranged script, and you're keeping data about how often they do some kind of an act, then is that data, would that be considered to be a person who you are collecting data from?
Yes, then that is a living person that you are collecting data about for the purpose of using or analyzing, or in some cases, even just having the data are enough to meet the definition of a human subject.
So basically, to be a Confederate that doesn't have to sign a consent form, they have to be following a prearranged script.
Yeah, pretty much. There are certainly, we've seen examples where they're not following a prearranged script, but the study team is not collecting any information about what it is they're doing, like
Okay.
once ever. For the most part, I'd say that that's a pretty fair dividing line that folks should be thinking about when thinking about who needs informed consent. Yes.
Thank you. Another
Yes, thank
one,
you.
you mentioned that you asked questions about the methodologies in part to discuss alternative methods. Is there a content expert for any field to give input into these amendments?
That's a great question. And Ron, even though you're probably better situated to answer this than I am, I'll go ahead and answer it. And the answer to that is yes. So when we are asking what an appropriate alternative procedure might look like, that question is actually for our scientific board members who represent the fields of study that we see most commonly before the IRB. So that question gets asked to our scientific reviewers during their review process. So do you understand all of the procedures? Do you understand exactly what the participant will be asked to do? And then are there alternative procedures that participants should be made aware of? Their options are like, I'm pulling this out of my head from memory, which is poor, but yes, there are alternative procedures and the study team has listed them. Yes, there are alternative procedures, but the study team has not listed them. No, there are no appropriate alternative procedures that need to be disclosed to research participants, and I think one other option. But yeah, that's all made by our faculty member. Those determinations are on our checklist for our faculty member board members.
Okay. I can't add anything to that. That's an excellent answer. Okay. There was another follow-up question about Confederates. It says, speaking of Confederates, do you still have inclusion and exclusion criteria for them? And does that count as asking for information?
If you are, yes. So if your Confederate is a research participant, then Confederate is just the way you're describing that research participant to us. So yes, you would still have inclusion and exclusion criteria for that set of people. And does that count as asking for information? Like from them? Yeah, in a way. I mean, the way you're finding your Confederates is to request either you have information about them already or you're requesting that information. And so in many cases, it's like I'm reaching out to this group of people who I know are the types of Confederates I would need. And so that all counts as inclusion and exclusion criteria. And then if you're going to screen them further for whether they would qualify to be a Confederate in your study, then yes, you would be obtaining information from them about, how they might serve as a Confederate. But really, like the important piece for whether someone is a human subject is the information that you're collecting or using about them, or even obtaining. So again, if you're recording it, you're obtaining it. And so that is the information that would need to be disclosed to them as the information that you are collecting about them. I think I've answered that question. I'm not entirely sure that I've addressed does that count as asking for information piece, but Ron, I don't know, maybe if there's context I might be missing there that you can think of, please feel
No,
free.
and I think it's okay because they wrote in
Oh, great.
thanks. So I think you must have hit it.
Okay. Why are there inconsistencies? If two studies have similar guidelines, why does one get rejected after the first one gets accepted? I would love a little more context there. In particular, we don't really disapprove studies that often. Ron can certainly speak to this as well. We approve studies and we work with people on revisions to get their study to an approvable state, but rejecting a study is pretty rare. I think fewer than 10 the entire time I've been with this institution, which is more than a decade now. In terms of inconsistencies across protocols in terms of review comments. So then we're not talking about rejections, we're talking about revisions most likely. I would say that the reviews are contextual, and so it would not be the case that we were reviewing two exactly of the same study, because then that would just be the same study and it would be an amendment, not a new protocol. But we would certainly recommend that you seek out a consultation if you are getting different feedback than somebody else did on a very substantially similar set of procedures. Because consistency is something that we really do strive for. And I don't pretend that we're perfect at that. So it's possible that we just need a little bit of guidance to being pointed towards something that was reviewed in a different way before. I will also say that a lot of concerns I've received about consistency stem from protocols that were submitted before the revisions to the common rule versus studies that were submitted after revisions to the common rule. That's something I do see fairly commonly, and that's just a matter of regulatory changes. So in 2019, new requirements were promulgated by the Office for Human Research Protections, and we implemented those, but they did have different requirements for different types of studies. I'm guessing that's not what this person is responding to, just because the registrant list looked like it was mostly students, so you probably haven't been here since the change in the common rule. So yeah, just reach out. We definitely strive for consistency. It's something that is important to us as an IRB.
And I would just add here that if you're proposing something that is similar in some ways to something that's already been done and approved, it's a good thing to put that in the proposal. Make sure we know what the other study was, and make sure it's absolutely clear to us what things have changed and what things have not changed. Sometimes different reviewers, if something was done a few years ago and now it's something like it is being proposed, well, just make sure we know, because, it's not going to be the same reviewer that looked at it a few years ago. It helps us to be able to go back to the exact proposal and understand what it is and what is being changed.
Yeah, there is no one person, not even me, not even Ron, in the IRB infrastructure that sees every single study. That would be impossible. We have so many submissions in our office. And so there's no sort of one keeper of 100% consistency, but we really, really do try to have standards that keep consistency across similar procedures, similar types of reviews. So again, referencing that previous project is great, but definitely do reach out if you feel like you've done that and you're still not obtaining consistent results, so that we can have a conversation about what might be going on there.
Great. When submitting a research proposal through the Kowali webpage, why do we have to copy and paste the same information in the manuscript and in different sections of the submission? For example, exclusion and inclusion criteria need to be at the same time in the submission sections and the manuscript. It's not easier to have only, is it not easier to have only one section for one type of information?
Yes, we would love that too. If there were a consistent proposal formula that all departments across Utah State University used, we would absolutely do away with a lot of protocol fields. But a lot of proposals that we receive are like 1 or 2 pages, and they don't contain the specifics of the information down to the level of inclusion and exclusion. And so our protocol template is designed to capture all of the information that our board members and our office needs in order to conduct a thorough review, with the understanding that not every proposal we receive looks the same. All of those uploads are very different across different fields and departments, and even researchers within the same departments. And we found that forcing a proposal structure also wasn't a best practice, because then we're getting in the way of how some students in some departments propose their thesis or dissertation projects versus how some faculty are proposing to agencies and how some are proposing to foundations. And so having one model for even what that proposal looks like really creates more work for people who are already doing quite a bit of work. And so in our view, a copy paste, if you've already had it, is the next least step to I don't have it, so I do have to specify it here.
And I would just add here that the guidance that is in Koali with respect to each of the fields in Koali is quite explicit and helpful. And so sometimes you may say you're just going to cut and paste something from the proposal into a field in Koali, but the guidance would, if you followed it, would have you put in some additional information that might not have been in your proposal. Yeah. Are there any other questions? If not, thank you, Nicole, very much for really an informative and helpful training. And I remind people that all of the trainings that we've been doing are on the IRB website, all the slides, and I think all the video as well.
Mhm. Yep.
So there are quite a few training topics that I think are extremely helpful, and they are on the IRB website under, I think, a training title.
Yes. So I think I'm sharing my whole screen and not just the PowerPoint. So I'll try to, I don't know if everybody can see this, but if you were on any page of our website, coming over here to this training, all of these trainings are here in our supplemental training. And I earlier mentioned the consultation request form that is also on every page of our website in the top right corner. And here's our SOPs. And here is where all of our informed consent templates live.
Great. And if any of you need information or are trying to find information and you're not finding it on the website, please let us know what it is you need and the problems you might have in finding it so that we can revise and update the website in ways that are the most helpful. So not seeing any more questions. Thank you all very much for joining us. And we'll look forward and we'll just remind you there is one more training session for this academic year, and it's going to be held on April 28th. And the title is I'm Approved, Now What? So we'll look forward to having people sign up for that as well, and we'll try to get that information out as widely as we can. So thank you, Nicole, one more time, and thank you all for joining us.